Your Honor, what I'd like to do is I'd like to start with Ms. Nassa. She's going to cover one of the requests specific to the grand jury subpoenas, and then I'll cover the rest of this morning's argument.
Okay, thank you.
Your Honor, to facilitate this argument on this point, I am going to hand you defense exhibits A and B that were submitted in our records for today. I want you to be able to look at them while I'm talking.
Okay, thank you.
As of today, there have been at least 50 federal grand jury subpoenas that have been issued in this case. Exhibits A and Exhibits B are an example of copies of grand jury subpoenas that we have received out of those more than 50. And what I didn't provide to you that goes behind that what we got with those is the subpoenas include attachment A, which explains what is being subpoenaed. And then what has been produced is the responses to those subpoenas. And in some of the subpoenas, we also have the certification by the person who has produced the records in response to the subpoena. Some of them are missing. We have asked the state to produce all of the subpoenas, and their response is that they are not in possession and control of those subpoenas, and they do not intend to use the subpoenas as an exhibit, and we have not justified why we need those subpoenas, and for those reasons, they are not going to produce them. I'd like to begin by saying that as it relates to any argument that the state is not in possession and control, rather than beat the dead horse on that issue, Idaho Supreme Court came down in 2023 and made it crystal clear that anybody that's acting on behalf of as an agent of the state puts those records in the hands of the state, and they need to produce them. State versus Pendleton, 2003. The other thing is that in terms of the state arguing that they are not going to use a subpoena as an exhibit, that is not in and of itself a defense to not produce a document to us. We have a million reasons why we need to look at documents. We understand that out of the 51 terabytes that have been produced, that not all of that is evidence that's going to be coming before the court or the jury, but it doesn't mean that they aren't material or exculpatory. The subpoenas, based on reviewing the records, are in the hands of basically three agents. There is an FBI forensic agent by the name, forensic accountant, Michael Douglas. There's a special agent, Travis Shirley, and there is another agent, Mary Tyndall. These are the three agents that are receiving the subpoenas, reaching out to the providers that they're serving and asking for the documents. For the court to understand why we need these documents, I want to tell you what we're doing with discovery and timelines. There are more than 100 search warrants in this case. There are more than 50 grand jury subpoenas in this case. You've heard all kinds of information about the probable cause affidavit and the timing of that. Timing in this case for the defense is everything. So we are creating timelines that put in the dates of affidavits of warrants, the information that's received, and the date that it's produced. With subpoenas, when we don't get a copy of the subpoena and all we get is the warrant or is the subpoena return, we don't know the scope of what the state has asked for. We don't know the date that the subpoena was served. And in some of them, we don't know that there is a certified return. So we can't take our timeline on warrants and our timeline on the probable cause affidavit and our timeline on everything else that we're putting in there and interlay the subpoena information that the state is getting. And we are desperate to find out the timeline in this case and when the state knew what and when. There's no question that motions to suppress are coming. Motions to suppress are coming on warrants. And whether or not those motions to suppress are based on Frank's material because misrepresentations are made depends on the timeline. So if there's a representation made in a warrant that things happened in a certain way, if we are able to look at the timeline and say, we know that the state knew this when, that gives us an answer on whether or not the suppression issue includes a truthful statement in the affidavit. And if I'm not making sense, I want you to tell me to clarify that. But We need to know the timeline of all of the evidence in this case and when the state knew what it knew, or why certain things were being looked at before Mr. Kohberger's arrest or well into late in the year in 2023 related to the victims, and try to piece together, is that something that the state is still seeking because they're pursuing the alternate suspects that exists in this case? There's so many things that we're trying to understand. So what we're asking you to do is enter an order compelling them to produce the subpoenas. You see that they had at least two in their possession that they possess, and it will clarify it for us. And we will be able to create our timeline and put all of these things together and know when and why the state was doing these things. And just to add one other component, you know, you're hearing about cell phone records and cell phone records today being produced on warrants. Well, there were several sets of cell phone records that were produced pursuant to a grand jury subpoena. Still not clear to us why warrant versus subpoena, and they're different providers. And some of it's for phone numbers that we have to figure out who those phone numbers are. But all of this information is critical and material for us to be able to do the case, to do our work in this case. So I would ask that you enter an order to compel. And that way the state has the ability to take that to the FBI agents and say, the court has entered an order, we've got to produce the subpoenas, and we'll get the subpoenas. And to the extent that the state may stand up and say, you know, we've got this 2E demands, we've got to deal with 2E. I just want to make it really clear for the court that 2E is not an obstacle. 2E is a hoop to jump through. The code related to 28 CFR 16.21 specifically states that the purpose of 2E is not to prevent federal agents from giving states discovery in a criminal case. The purpose of 2E is because these federal departments want to know when certain records are leaving their files. Understandable, but it's not meant to keep us from getting records that we need in this case.
Thank you. Response? And
Well, simply put, we can't give over what we don't have. And we do not have the majority of these subpoenas. What we do have, we've turned over. I reached out to the U.S. Attorney's Office. They advised they're not going to provide.
what? Why?
Because they don't provide subpoenas. You know, just like most grand jury material, it's sealed and not typically provided.
Not typically.
Not provided.
But even with a 2E letter, that wouldn't give it. We provide. They wouldn't follow that.
We have not. I'm not sure. But beyond that, though, even if they were to provide it, I still don't understand how this moves the needle one way or the other. You can tell I've detailed there's 71 federal grand jury subpoenas. And in my response, I've detailed exactly what they were for and what records were received so that you can get the scope of what was requested from the actual records. The piece of paper that was given over saying, give us these records is all they're asking for. But they have the records. They have the important part of this.
So they have the timing based on the subpoenas
Off of
that
the
you
records.
provided to the defense.
Off of the records provided. You can tell the scope as well as what they're for. And I've detailed exactly what they were for, the scope, in my response.
Any response?
Judge, I wouldn't be wasting the court's time asking for this if the questions were answered based on the state's response to our request for discovery. Timing is critical on when a subpoena is served, what was the scope, then we can look at the documents to see if they're actually responsive to the scope. And knowing the timing of when that was served versus when it's produced to us is different. And again, I mentioned some of these things are pre-arrest of Mr. Kohberger, and some of it is in the middle, and some of it is, frankly, months after the fact, if not a year after the fact, where they're looking for things related to the victims.
And can I ask a question? Because Ms. Jennings just said that that the dates, well, all the subpoenas that were provided to you, 71 subpoenas, and each one of those had the scope of what the request was in the subpoena, and that it would be dated. No,
That's not true.
that's not.
That's not true. Yeah. There are all kinds of different records and different methods that the people that were the businesses and the people that were asked to produce the records produce them in different form. I do not know when they received the subpoena, the timing of it, and I do not know for all of these what was the scope of what was asked for versus what was produced. I do know what's produced, but I don't know the timing. And the answer of the date discovery provided, which is in Exhibit 1, that the date that a discovery is provided to us doesn't answer the first two questions that I have, which is the timing of when they asked for it and the scope that was stated in the subpoena of what they asked for. Some companies were asked probably for a certain number of months, and they didn't have records that were responsive to those number of months, right? Because when the state's doing this investigation, they're not necessarily knowing exactly what records exist. So being able to be specific is important. And I want to touch on this issue of it. It's not in their possession. I get that. But you have complete control over what evidence is going to be coming into this case with your orders. You make it crystal clear. Produce it or it's not coming in. That's the first level of sanction. And then we can just get going from there. You know, something that's destroyed, you can't produce that, there's going to be a spoliation instruction. Something that we keep repeatedly asking for and it gets past time, we're going to knock the death penalty off the table. You know, you have control to get these issues that we are struggling with fixed by saying, this is my order, produce it, or there's going to be a sanction.
You may be overestimating my power.
I think you're underestimating your power.
Well, I have a good sense of where my power starts and ends. So I don't know. I mean, there's so much discovery that has been shared. Are all of these 71 subpoenas, have they been provided to me at this point? Because I don't think I've seen them.
No, they went through a federal grand jury. So this, you know, we haven't seen anything in terms of grand jury testimony, transcripts. What I have surmised based on my federal practice, because I spend about 50% of my time in federal court, is that they've used a federal grand jury as an investigative tool because the FBI is partnering with them. That makes complete sense. These subpoenas are in the hands of the 3 agents that I gave you the names of. They haven't come through you. They're in the hands of the agents. And so it's a matter of them just gathering the records that those agents have in their possession and providing to us. You know, and it helps us create this timeline in a case where discovery is being given to us as if we're living in a snow globe and it's just swirling around us and we're constantly having to put it together. So, you know, you've asked us several times, what can I do to help you guys get your work done? This is one of those things. Let us see the subpoenas so we can overlay this in our timeline.
But you just want the subpoenas. You don't necessarily are going to get the response.
We have the responses. We have the records. But what the records don't tell us is what was in the subpoena. It's like a warrant return. What is a warrant based on? It's based on an affidavit.
So
right?
this is what you want, the paper that says
And the
this is what we want.
And the Exhibit A that's attached to that, which I didn't give you a copy of Exhibit A, but Exhibit A is attached to each one of those, and then it specifies to the company, you know, you're looking for phone numbers that are this, and this for these dates.
It doesn't have the date on it when it was served?
Those subpoenas tell us we know when they are served because it comes back with a date on it. And then, and then attachment A has the scope of what they've asked for. What we've gotten is the documents without, it's like not having the affidavit to the warrant return.
Okay. I think I understand that. And I'm going to go back to Ms. Jennings and just clarify. What have they been given already?
They have been given records in response to all 71 of those federal grand jury subpoenas.
Do they have dated on there? Because that's...
Many of them do. You can see that from the description of the contents that I provided to the board. I can't say that all of them do, but many of them do.
Well, that's very important, apparently, for the defense, as Ms. Mathis said, that timing is everything here. So I think that's what they're really after. That's one of the things they're after, is just the time frame.
we can seek to inquire as to, because what I keep hearing is they need to know the date that these various companies received the subpoena. We can still inquire. It's provided on a lot of these,
Right.
but on the ones we're missing, we can attempt to inquire and find out the date that it was served, and we can still do that without providing the piece of paper.
Well, besides the timing, what's the relevance to this scope that was requested? And
What's the relevance? But
Yeah.
we're not relying on any of this.
I know. I don't think you're. What do you think they think is relevant?
Yeah, for sure.
Okay. So what is the relevance? But aside with the timing, okay, and the scope.
Judge, I'm not going to give you the specific date right now in open court on one of the subpoenas, but they used a subpoena to get one of the most critical pieces of evidence in this case. And they know that.
Okay.
And they are going to use that.
It's something that I don't know about.
Well, I mean, you probably you do know of it. It's in the probable cause affidavit.
Okay. Thank you. All right. Ms. Jennings,
What I can tell you is that for the majority of the stuff, we did state search warrants, and we've received many of these records that way.
Okay. Thank you. All right. Enough with that. Thank you very much. Appreciate it. Maybe it's a time to, well, let's see, where you still have your argument.
Yeah.
How long do you think?
Your Honor, my intention is to talk about the law that governs discovery requests and ask you to compel certain things. I'm going to go through our 4th request. I'm going to tell you a few things that we have, and then I'm going to tell you why you ought to order that the state give us the rest of it, how it's material to us, and how it's in the possession and control of the state. And I'm going to do something. I would say I'm going to talk 15 minutes, maybe.
Okay, great. Go ahead.
Thank you. Your Honor, then where I want to start is with Idaho Criminal Rule 16, which governs discovery. 16A directs which things are mandatory disclosures from the state. Those are things I don't even have to ask for. And those are items that the state has possession and control over that would tend to negate guilt or reduce punishment. 16B is the portion of the rule that governs when I request items in the course of my preparation of the case. And I would have the court keep in mind 16A and the prosecutor's responsibilities and Idaho Criminal Rule 16B and the discovery requests that we've made and what we have not received. We've asked for documents, we've asked for reports, we've asked for qualifications and summaries from experts, and we've asked for media that's been gathered in the case. The court can order other things that we asked for based on the need of the case. I would remind the court of the case that Ms. Nassif just talked to the court about, State versus Pendleton. I know the court's familiar with this. This is a good case because it's recent and because it takes the time to define what's material and what's within the possession and control of the state. We need to think about our motion to compel in the order we are requesting from you in the context of what's in the possession and control of the state. Your Honor, the State versus Pendleton case says that any law enforcement, and this includes the prosecutor's office, it includes their staff, it includes any law enforcement that worked with them on the case. In this case, you're looking at Moscow Police Department, Idaho State Police Department, Idaho State Police Forensics Lab, and FBI agents, to name a few. So what those entities have and have developed are within the possession and control of the prosecutor. So with that backdrop, I want to run through our specific requests and talk about what we need. You've heard testimony, and so I think you know why these things are material, but let's go over it again. Starting with the 4th motion to compel. Ms. Nassif went over 1A, the grand jury subpoenas. I'm going to leave that argument alone. She did a fabulous job with that. When we're looking at 2A, this all comes from the defendant's 11th supplemental request for discovery. 2A is the video on King Street. Your Honor, we began asking for that a long time ago. We have it in full, so we don't have to talk about that. We received that full or all of the hours and days in question with both audio and video on 510. So we can mark 2A, item 219 off of our list.
219.
219.
I've gone through pages and pages and pages. So I think I really appreciate you being very specific about, what you have now and what you will still.
Okay. good, because it's the only way I can keep track of it.
Yeah, well, same here. Thank you.
You're welcome. Your Honor, item 2B in our fourth motion to compel is item 224. That's the CAS biz log. And this one is rough. The court heard last week Detective Mowry say, I don't have any of those, except I found these other items that we'll give you now, which were not Mowry's CAS biz logs. The hard part for us about this one, Judge, and I have to make a record, I think you can order them to double check, and I'm going to ask you to order them to double check. But the hard part of this for me is that on January 9th, we asked for these CAS biz logs. And the response was from the state was CAS biz does not produce logs. And that's just not true. It does. It's capable. It produces logs. You've heard that in the testimony. Then we filed our motion to compel and explained we have an expert. We know it produces logs. We're going to bring them. And the response was the working files were not saved. We received that response on April 23rd, 2024. And then on May 10th, we got a little bit more explanation about default settings were used and optional session files were not uploaded. This is really, really difficult because of the varying answers that we've received. The court's heard testimony from Mr. Ray about how important these logs are to know what was done. This is really challenging. We can't recreate what Detective Mowry, who testified before the grand jury, did, unless the court orders that we get the tower list he used and we have the CAS biz program. And quite frankly, that's what we want. We need to see how this work was done. This is important work. I'll tell you the other thing that's really troubling and frustrating, aside from the other files that we received in preparation for motion to compel, is these screenshots that we got for the first time last week when we're on a motion to compel and have a witness before the court. We didn't have those screenshots that Detective Mowry had created before. The only thing we had was Exhibit 48 that was given to the grand jury, which is a video that was handed over then. So this is really problematic to be told these varying things and then have something else produced on the day of testimony. Your Honor, we are going to request that the court order that we have the tower list used by Detective Mowry and access to the CAS biz program so our expert, Mr. Cy Ray, can go through and see what Detective Mowry did. That it's imperative that we be allowed to do that. That's the only way to recreate what Detective Mowry did.
It seems to me he did acknowledge that he just went back and provided this a day or 2 days before he testified that he found this additional information. So I'm thinking that the state got that information and had provided that to you. Now, we also heard a lot of the quotes missing pieces today, which I'm guessing that FBI, Mr. Valance, and Detective Mowry are going to go back through that and see if there's something else. At this point, I'm assuming that some things may have fallen through the cracks. I mean, it is very complicated. There was a lot going on. We have some time before a trial. I just hope that everybody goes through their computers or their files or whatever they're going through so that it's complete. So what I've been watching over the last 2 months is that there have been supplemental responses to the defense. So things were coming in. They were waiting for information to come in so that they could provide that to you. So that's why I don't want to go backwards either. I just want to make sure that we are addressing what you don't have and what actually you're entitled to. So that's the tower list. I mean, I don't know anything about tower lists, so I'm learning about that. I don't know that Detective Mowry addressed that, unless I missed that.
Your Honor, I believe he testified last week that he used the tower list that was contained in the AT&T record that he received. You heard today that that doesn't exist. And you heard today that the tower list was something different that he used. And that tower list had once that was entered, there was a selection on the program to do tower density as well. Like that.
Like I said, it's confusing.
It is. It definitely is.
We'll keep going.
Okay, thank you.
You want the tower list?
Yes, I think I'm getting that, but I definitely want that. I want the one that Mallory used to do his cast viz work back in May of last year. That's the one I really want right now, at least at this juncture in the documents right now. I do want to clear up though, when we talk about what Detective Mallory found last week when he was preparing to testify, those are emails between him and Nick Valance. Those are JSON files from Nick Valance to Detective Mallory. None of those things that he found, other than screenshots, like the exhibit that you have of his map with the different sized towers depicted, other than those screenshots, the other things he had came from Nick Valance. Those were not his logs that he found. Those were not his towers that he found, just to be sure that those are still missing to the extent they exist. And we can't recreate what he did without the list and project. Moving on.
Thank you.
Moving on then, Your Honor, is item 226. That's called the Hemisphere Program, also known as a Timing Advance Report. Your Honor, this is one of the troubling areas again. The first response was that the records do not exist. There were letters exchanged between the state and us asking for more information. In one of the letters from the prosecutor, we were told that this program was not used in Bryan Kohberger's case. And then we filed a motion to compel, and we were told that the state was not in possession of the timing records. And then the next supplemental response in May of this year, just a couple of weeks ago, was to tell us that there's some new certified records from AT&T that we're going to get. I don't know what those are. I can tell you that these timing advanced reports were asked for from AT&T, from Verizon, from T-Mobile, and another cell phone company in both of the early AT&T warrants. We called them the 48-hour and then the extended warrants back on December 23rd, 2022. We don't have those. So I just want to make a record that I need to know what happens. Moving on then to 228, item 228, that was trying to understand what was relied upon for the second AT&T warrant. And we heard quite a bit today from Detective Payne about what he relied on for that second warrant, and that had to do with what was produced and analyzed in the first warrant. However, we asked for some emails and some communications. We know about some text messaging that we've received, but we don't have written correspondence, email correspondence, exchanging information, just the text messaging. So we want all of the email communication between Payne and Valance, or between anybody from Moscow PD and anybody from the FBI. Your Honor, item 229 is the MAID data. I would say we received a disclosure, and I think we got that on either 510 or 517. And I'm going to need some time to have an expert help me out with that. I don't know if that's complete. I also know that in the fifth motion to compel, there is information we've asked for from Babel. That was a program that was used to help decipher some of the MAID data. And we're going to talk about that in a minute, but that one's yet to come. So I'm going to ask the court for an order compelling the state to give me all the MAID data. They may have already complied, though. And their intent to comply, I can tell you that.
What does that stand for again?
Mobile advertiser. Let's see, I've got it in here.
Okay, I'm glad.
Identification number. Mobile advertiser identification number.
Okay, thank you.
You're welcome. All right, Judge, we are now talking about item 242, the cast report. The history of this is we came to the court asking for the cast report, knowing it was relied upon last year, and the court ordered that we receive it. We received one that was stamped draft all over it. You've heard testimony about that today from Mr. Ray, and it's not a final report, and we knew that when we got it. We asked for that. We asked for the analysis behind that, and we haven't received that. We were told on February 23rd of this year that the state will provide this by March 31st. Well, March 31st came and went, and we did not get it. So on April 23rd, the state said we still don't have it. And then on May the 10th, the state responded to this request and said that because we provided additional information, Mr. Kohberger's alibi, they need more time to do work on this cast report, and they'll get it to us later. Your Honor, I think you ought to order that we get the cast report And I think you ought to order that we get everything that went into developing this, and we get the analysis that they made from that. This is particularly troubling. Their response, you told us something, so now we have to go reconfigure the CAST report. Let me tell you why that's troubling. Item 243 is our request. Give us a list of everything Nick Valance relied on when drafting his CAST report. And we were told Nick Valance relied on the call detail records from AT&T. Nick Valance relied upon tower records, and he relied upon the drive test data. Nowhere in there does it say, if you tell us anything about the case, we need that to rely on that too. These are records that exist. These are tower lists that exist. They go into a program. You do drive testing to understand how the device interacts with towers, and you create a report. So we're asking the court to order that we get the CAST draft report, we get the full list of everything he relied upon, and we get the analysis of what does this mean.
So another clarifying question, maybe. So I listened to the testimony today, and that it sounded like a CAST report was provided, but maybe it wasn't complete, is what Mr. Ray suggested. But I think that I'm guessing you're assuming that the state provided what they had, but it maybe they're still working on it. I don't know. But didn't you get initially what they had as they characterized as the CAST report? So what would you say? I mean, we have problems with language, I think, especially when we're in this area, technology. And so we might be just going back and forth like this without really understanding what we're asking for or what we're providing.
Let me see if I can clear that up. The testimony today, when we had Detective Payne on the stand, when we talked about what did you rely on to get the second AT&T warrant, he said that there was something that Nick Valance produced and that the prosecutor had it, and he thought it was a CAST draft. And then you heard from Mr. Ray, who said, I've seen a CAST draft report, and maybe it's something different that Detective Payne looked at. It wasn't this big, long CAST draft. The CAST draft report, and I'm calling it draft because it's stamped draft. I knew it wasn't final when I received it. We got that because you ordered that the state give that to us last July. So I had this draft. I knew it wasn't final. Ms. Jennings knew it wasn't final. We've talked about it. We believed that we were going to get the final report by March 31st. We don't have that yet. It's the final report that we need. You also heard from Mr. Ray talking about the things that are mistakes in the CAST draft report. These reports go through a peer review process, and they can look a little different when they come back out on the other side. Usually not vastly different, but they can. They go through their process. It's that final product that I need that. I need to know everything they relied on to do their work. I need to know what this draft report is going to look like. The court should know that when we get to trial, likely Agent Valance is going to come in and talk about his CAST draft report. He's going to be an expert in the field and talk about what he found and why he found and what he relied on to do that. I'm going to come in with an expert that's going to explain what his work did. Now, if the work aligns and Nicholas Valance and our expert aligns, well, that's just going to be shorter. But right now, it's definitely not looking like that. It looks like they're going to have their side, and we're going to be talking about what the data shows. So what I want is the final report that we were told would be available by March 31st. I need time to work on it.
Sure.
What I want is a full list of what was used to create that report, what was relied on. I have to be able to see if I can recreate that. I have to see what was right with it and what was wrong with it. So I don't have those two things, right?
Is it possible that it's just not completed?
It is possible.
A final report?
It is possible, but I need you to order that come to me. And I don't think Ms. Jennings doesn't want to give it to me. But if you order that I get it, then I'm going to get it a lot sooner, I think. I'm not saying that Ms. Jennings is sitting holding it behind her back. I'm saying I don't now know what's going on. The FBI told her it was going to be in by March 31st. We hit our deadline to disclose our alibi. And all of a sudden now they need to redo something in the report, which shocks me because of the things they said that they relied on were things that already existed. So now I really need to know what they're relying on to do this report, and I really need to see the analysis, and I really need to see the final report.
Sure.
I have to react to it.
Since we're talking about this, Ms. Jennings, do you want to just respond to that? whether or not this is still a work in progress or what's going on.
Right, Your Honor. As I know right now, that report is not in its final form, and it has gone through a peer review process. My understanding is it's still in that. I have been told that yes, it's not a matter of redoing anything, but as they receive additional information, they just want to double check their work. They want to make sure that when they get the final report, it's accurate. So we are still waiting for that final report to ensure that it's accurate. And as soon as we receive it,
I'm sorry. You have a time frame for that? I told you when they expect to be finished.
I don't have a final time frame. They originally told us it was projected to be completed by June next month. So I'm hoping to get it within the next month.
All right, thank you. Appreciate that. Sometimes it's easier just to sort of a particular issue at the same time.
Some of the hot ones it might be, Your Honor.
Yes.
Your Honor, I do think we have the regional tower list now, so I think we're good with that. On item number 220, 244 and 245, we have those documents now, so we're good there. Moving then to item 248. This is the drive test data, the mapping data. The court heard pretty extensively that we've received this in two places. We received some early on, and then we received a lot more recently, but it appears to still be missing some. Asking the court just to order that we receive the entirety of all drive test data that was conducted by Agent Balance or anybody from the FBI. 249 is anything that exists after January 6th of 2023 for the drive test data. That's number 249. And so I would ask the court to order that to the extent that it exists. Would ask that it be ordered to be produced. Item 250 is the training and certification records for Nick Balance and Sean Kennedy relating specifically to the use of the Gladiator or the GAR. That's the item used to conduct these drive tests. Your Honor, I think that we gave the court a transcript of testimony of Nick Balance that occurred within the last year. And that transcript had highlighting on it, so the court didn't have to read the whole thing, but to look at how many times the training and experience was relied upon by this expert, and that expert's Nick Balance. And if he's going to be a testifying expert, the discovery rules allow for us to have their training. We asked for it specific to this Gladiator because we know that's going to be a big part of his testimony. So we're asking the court to order that we receive his training and certification records relating to the GAR product. Similarly, now we'll talk about the GAR unit itself and its calibration records or its certificates that it's in compliance. The court just heard the testimony from Mr. Ray about how important that is, that often they get tired, things go wrong with them, and they get restored to service. We do have 2 certificates, but what we need is what Mr. Ray called the bookends, so we need the other side. We know that it came in non-compliant and that it was restored and went back out. We don't know what happened after it was used, and we don't know the next bit of calibration that it went through. We don't know how it checked out. So we need the full copy, the bookend copy of the calibration reports.
This is still in 250.
That one is 250, yes. Sorry, Judge, I think that might have been in 251. That wasn't 251. 250 is the training records for the agents, and 251 is for the calibration records for the instrument. I apologize for that. 258 is a request for all information, all data, including all expert reports that the state has relied upon in developing the affidavits in support of all warrants.
That's like a big one.
It's a big one. And the state responded with an answer saying, these are the things that have been relied on. I'll tell you what my concern is, that there are things maybe in computer files, things on somebody's desk that haven't been turned over yet. So I think the court ought to order that the state make sure they've given us everything that was relied on for every single one of the warrants. Ms. Massa indicated to the court, and I know that other members, I think Mr. Logston has indicated that we're going to have motions to suppress. And so we want to make sure that we have all of the information. Possibly it would answer questions so we don't have to have quite as many. But
so we don't have to what?
Have quite as many motions to suppress.
Okay, thank you.
That's not a problem.
I understand.
All right, Judge, let's talk about the 5th motion to compel. That completed the 4th. The 5th motion to compel, we are not going to talk about the 15th request for discovery until this afternoon. So my comments will relate to the supplemental request for discovery, number 12, number 13, and number 14.
12, 13, 14.
Yes. In Request number 259, number 260, 261, 262, and 265. The state has let us know that these are coming. They responded on May 10th and said these are coming. They don't have a problem. So we're asking the court to order them to be disclosed to us. I think these are some that aren't going to be available for a while, but I think the court ought to order it. The state doesn't seem to have an objection to us having them. The order will mean we don't have to come back if something doesn't get through to us.
Okay, can you give me those numbers again, please?
Yes, I can. It's number 259, number 260, number 261, 262, and 265.
Thank you.
Your Honor, 289 related to communications between Detective Payne and the WSU officer talking about white elantras. I believe that that's been covered. Payne testified today that we have the instant messages and there was only a phone call and that was it. So to the extent that that's the very end of it, then we're fine. And so I think we are on that one. Item number 299 is called a tips lead sheet. And that's something that's referenced during the course of in the discovery. We were asked for an example that was sent to the state. I'm just going to ask the court to order that be disclosed to us. Number 300 relates to emails, notes, and other communications. The state's responded with 3 separate AB files, and I'm going to ask the court just to order that they all be given to us. We may have them all, but I'm going to ask that the court just order that just to be sure that we have them. Well, Your Honor, I take that back. I spoke with Ms. Jennings, and I know there's one area. I'm not going to talk about the area, but I know there's still one area that we don't have, so I'm going to ask the court to order that all emails, notes, and communications be produced to us. Remember, the next item is the CAST certification and training for Nick Valance. And for many of the same reasons that we asked for that for the Gladiator, we need to have his training records. He's going to come in as an expert. The discovery rules cover this. You can see an example of him testifying as an expert in the transcripts that I provided.
That's not covered by 250?
250 is the training related to the Gladiator specifically. This one is relating very specifically to his trainings for his CAST work and certification for his CAST work.
I'm sorry, but then what was the number for that training?
I do not think
that's 300.
That one's not 300. Let me find out. I didn't write that number down. Give me 263. Counsel saved the day.
263?
And 264, I believe, relates to Sean Kennedy. Yeah, he's another FBI CAST person. And I am now at. Your Honor, items 274, 275, and 278 have been provided. Item 287 relates to a new expert, a blood spatter expert that the state is working with. We're told that that's going to be available in June. It doesn't seem that there's an objection. We'd ask the court to order that to be provided to us once received by the state. Request 289 we have. We're now at the 13th supplemental request for discovery. And that one is 302, item 302. That's similar to several others. So I'm going to hold the argument on that for a minute. I'm going to let the court know that items 303, 304, 305 have been provided to us, except there's going to be some raw data provided to us. And to that extent, would ask the court order that we receive the raw data that have otherwise been complied with. Items 306, 309, and 308. The response from the state has been that we've now worked through the 2-week process. That letter's been given to the FBI, and so we may get those by early June. So we'd ask the court to order that those be produced. I don't think the state's objecting to those. They just don't quite have them yet. 307 has been provided. Your Honor, 313. Those are the Department of Transportation cameras. We heard testimony about that last week, that there was a letter preserving still shots, but not any video was available. So I think that that's been complied with to the extent that it can be complied with. 314 was the email communication, and we received that, so that's been complied with. 316 and 315, I believe, are also subject to the 2-week letter, so would ask the court order those be provided as soon as they're received. And now moving on to request 317, 322, 319, 320, 321, 323, 320, and 324. And then picking back up with 302, those are all surveillance camera items that we've requested. We're asking the court to order Moscow Police Department, as the custodian of these things in this case, to do an inventory of what's there. You heard last week that Detective Mallory said, I don't have the videos, those aren't my responsibility. You heard today Detective Payne said it's Mallory and FBI agents. So we take Mallory out of the equation. He says, I didn't do it. I can't tell you where these videos are. I don't know who the FBI agents are. So first, I think the court ought to order that be disclosed to me. The second offer was that I can go to the Moscow Police Department evidence room and go through hundreds of hours, thousands of hours of videotapes, and that's just not reasonable. These are videotapes that have been collected in the course of this investigation. You heard Detective Payne say that when he looked at cameras on South 95 and the other road, south of Moscow, on the date in question, and in conformance with what he alleged in his affidavit of probable cause to arrest Bryan, he looked at those videos and he didn't find a car. That screams stuff that's exculpatory to me. I need to know where these videos are. They were collected. The court can see that from the reports that we put in the packet of evidence. The court knows they've been collected, but nobody can tell me where they are. And I need help. I don't physically have time to go watch thousands of hours in Moscow Police Department and be efficient with the case. But if that's what I have to do, I guess I need the court to tell me that's what I have to do. I think you have the ability to order that there be an accounting of all of these videos. Keep in mind, what we heard today was exculpatory. So there has to be a duty to categorize all of these videos and get that information to me. Go find these videos that other police officers turned over to Moscow Police Department that are in relevant areas. That's just critical, and that needs to happen.
So I did look at a long list of videos that were provided to the defense that said there was nothing there, or the camera was broken, or so there was some kind of inventory there, and we saw that, right?
Yes.
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 Okay. So what you want now is just a complete inventory of all of the videos that they obtained.
That would be appropriate to have that, but there are specifically named videos in this fifth motion to compel that we specifically want the videos. We know they're there. We've read the police report.
Okay, if it's 317 through, I don't know, 324, you're saying that those are specific. There's videos that you want, that you think you know are in this inventory.
Well, I don't know if they're in that inventory. I don't have them. I know they were collected and given to Moscow Police Department. I want to know where they are. And we listed out in 317, in 322, 319, 320, 321, 323, and 324 different locations that say we collected these. We gave them to Moscow Police Department. That's what I need to know. Where are they?
You didn't get any of these videos of this list that you just gave me?
No, of that list I gave you, I did not. There was also one that I asked to be included. I'm coming back to that number. It's 302. We did get a time frame on the day before the incident, and so I need to know where the time frame after the incident is.
Okay.
Thank you, Judge, for that. I'm close to being done. Number 325. The answer was that if there was communications, it would have been a call. So that one's fine. We're good with that one. Number 326 is Uber logs between Detective Mallory and the Uber company. They've been provided to us, but I can't get into them. They're password protected. Miss Jennings and I have been trying to work that out. I think she'll continue to try to help me, but to the extent that it doesn't work, I'll need a copy that does work in some form. 336. 336 has to do with records, and I believe that Miss Jennings has provided or is providing a police report that will indicate these records don't exist based on an interview that was done. So we don't need to do anything with that one today. And I think the rest of them, 335, 336, 337, 338, and 339, the state has indicated that we've been given everything there is and nothing else exists. This all has to do with vehicle identification, and we're talking about identifying a car in question from a video as being a 2011 to 13 long truck. They say we have it all. So if we have it all, that's great. I just don't want any surprises. Again, Your Honor, we think the court should order the things as we outline. Their material to the preparation of our defense. I would remind the court that relevance is the standard of whether it gets in front of the jury, but it's a different standard when we're talking about materiality. So I was talking about the Pendleton case, and I know the court's familiar with the Pendleton case. The court wrote about that in a previous order.
Yes.
So I'll leave it at that and just request that the court order these things. So
I'm at that list at the end about the identification of vehicle. You're saying that they have provided that to you, but they're telling you that's all they have.
yes, there are specific items that they say, we gave you everything that's there. The rest of these items don't exist. It has to do with cameras and camera angles and different things like that. It's spelled out in the fifth motion to compel.
Okay.
I just don't want to be surprised.
You just want to make sure that if they find something else, they provide some supplemental response.
Well, I'd be concerned if they find something else after they said nothing else exists.
They're shaking their heads right now, but you never know. So, okay. Thank you very much.
Thank you, Judge.
Ms. Jennings.
Thank you, Judge.
There's a lot of stuff there.
Yes, and I'll try to make this quick. I'll kind of go through each of these items that are still out there for discussion. But just to give you a little bit of perspective of what all has been provided to date. The state has
I rest assured, both sides, that I have gone through page after page after page after page. So yeah, I understand. I have some perspective about what's been going on and how hard both sides have been working. So
and just to give a little context, why this isn't just so simple. To date, we've given 15,691 bait-stamped pages of discovery. So for a little context, this is a 2-inch binder. It would be about 39 of these. We've given 13,758 bait-stamped photographs. That's about 34 of those binders of photographs. We've given 911 AV dumps. Those are digital files, in addition to a massive hard drive, about 50 terabytes full of discovery. And that includes audio video from about 285 interviews, 15,000 video clips from approximately 79 businesses, 8,000 video clips from approximately 10 residences, 417 files containing call detail records, multiple terabytes of records for 11 computer devices, 17 cell phones, multiple social media accounts, and 4 tower dumps.
Excuse me, Ms. Jennings.
4 tower dumps. In addition to records regarding well over 17,000 tips. We've given multiple terabytes of records in response to the 71 grand jury subpoenas, as well as the 101 search warrants that were done in this case. We have facilitated the defense viewing the physical evidence on multiple occasions, as well as facilitated additional DNA trace evidence to be examined at their request. We've had a consistent pattern of loading up discovery and providing a hard drive to the defense on an almost weekly basis. And just to be clear, we're going to continue to do that. As we receive discovery, we review it, we load it on our hard drive, and we give it over. Now, going specifically through each of the requests, we've already dealt with in the fourth motion to compel. Item 214, we've already argued. Item 219, we've already complied with. The CASVIZ logs. You heard the testimony, and what we know and what the judge heard testimony for is that CASVIZ is just a software program that allows investigators to put in like the records received from a cell phone provider like AT&T into a software program and they kind of visualize. Detective Mallory testified he got the raw data set from AT&T, used the default settings for the times in question. It produced a map. He took a screenshot of that map. We provided that screenshot. He only did this in response to our request to provide a visual for the grand jury. We've been told that optional session files were not created or saved, and that this item simply doesn't exist. In the current version of CASVIZ, the user settings aren't automatically saved in an exported session, but instead it just returns to default settings. I asked Detective Mallory about this. He advised us that he used the default settings. It doesn't take much time or effort to redo this, which is why he didn't save those logs. That's his normal practice. He just saved the screenshots, and we provided that. We agree. We will double check. We're doing that throughout all of this. To our knowledge, there are not tower documents that were relied upon, but we will double check and inquire, and if that exists, then we will turn it over. 226 has to do, well, first the request was for the AT&T Hemisphere program, and then it detailed several other things below it. And we were told they didn't use the Hemisphere program. And you're right, language is important as to exactly what's being requested. And now after a series of back and forth, they're saying that they want AT&T timing report. We have been told if that's referring to timing advance records, those records don't exist. We do have these location records, the DBOR records, and we've given those over. Now, the second part, it says that investigators recently obtained certified records from AT&T, and that'll be disclosed in upcoming discovery production. My understanding is that that's not related to the above. It's not related to Bryan Kohberger's records. It's related to other records that were done later for other folks, but we will be providing that in the next production doc. Next is 228, complete copy of all materials relied upon Corporal Payne. To our knowledge, we've turned all of that over. We have given the documentation of correspondence between our CAST agent, Balance, as well as with Detective Payne. And he testified today that the only other communication, they were together. So they were just relaying things verbally, and that he was including that information in his report.
Can you give me the numbers too? Because I'm trying to keep track.
I am on 228.
Thank you.
229 has been complied with. Now we're at 242, a complete task report. We've already discussed that.
When you say complied with, does that mean that both sides agree that it was complied with? Or is it that you saying that you complied with that, but they are still asking for it? I just want to, speaking of language.
Well, I can't speak for the defense, but to our knowledge, we have provided everything that relates to the MAID data.
Okay. I just want to be clear about that. So if both sides agree that this is done, we don't need to keep arguing about this. But if the state is saying, well, we've complied, but they don't agree with that, then that's something I have to deal with. Ms. Taylor.
Your Honor, there's so much here. So the clarification on this is they did give us MAID data. I've been working with our expert and we think that all the data is there, but part 2 of it has to do with the Babel information that's coming. That's in the 5th motion to compel.
And that's a great
good one to remember. Yeah.
Yes.
And so I need that to put those 2 together. So I think the MAID data we have, I need to reserve though and say once our experts have full time to look at the MAID data, once we get the Babel stuff as well, then we may have a problem. But they did do a disclosure. For sure they did do a disclosure. I just can't say it's all of what we were looking for quite yet.
All right. So some of these we might come back to me to say, okay, where there's something missing or everything's fine.
And I will speak with Ms. Jensen if I notice that ahead of time too.
Okay, thank you.
243 relates to the final draft of the task report. 244 is done. 248, there's still some questions about. I will say that Ms. Taylor reached out to me last week, letting me know that they believe there might be some missing pieces there. I reached out to SA Balance, asking, he was at a training all last week. I've been told he's looking into it to see if there is additional information, then of course we would produce that. That's all I know at this point. 249 is related to the above. 250 to the state belief, that's been done. And 258, again, this is a very broad request. If there's something specifically that they're looking for, that would be helpful. But as far as the state's concerned, we've complied with this request. We've given you the returns for all of the 101 search warrants that were done, as well as the affidavits, which detail exactly what the investigator relied upon in order to obtain those search warrants. Again, if there is something specific that they're seeking or looking for, if they can provide that to us, then we will inquire. Now we move on to the 5th. Items 259 through, 259, 260, 261, 262, and 265. Yes, our answer is that we have inquired. We've been told that this is coming. The employee responsible for these items is out on medical leave for about 6 to 8 weeks. We still have probably another month left before she returns, and then would need time for that to be completed. But we do intend on giving this over. As we've done already, as we get it, we turn it over. Item 289, this is completed. 299, tip lead sheets. State has provided information for well over 17,000 tips in this case. We've been advised by the FBI that they believe they provided all information related to tips. Now, I'm unsure if there are duplicates of the same information. We will inquire, but substantively, it's our understanding that they have all the information for the 17,000 tips. But yes, I will inquire and see if there's something, a tip lead sheet that can be easily provided. 300, this has, for the majority, already been provided. They already have the ISP and PD emails. I've talked to Ms. Taylor about another certain section of emails that she would like to see. I will inquire about that, and if they exist, we will turn them over. 263 and 264 have to do with CAS certification and training records. I can tell the court, we're going to comply with this. We're not at our expert discovery disclosure deadline, and we're just not at that point, but we will be. And we plan on giving this over on anything we intend to rely on. 274, 275, 278 have all been done. 287, this is an expert analysis. We haven't received it. We are expecting to receive it sometime in the next month. As soon as we receive that, we will discover. 289 is done. And starting with 302 is when we get into all these different surveillance videos. We have provided them a list of all the videos as they're labeled and as they're stored at MPD. Now, yes, we will do our due diligence to make sure that what we have is turned over. To date, though, and we'll continue to do that. To date, we have located a Watson Carey construction video, but the only thing we've located is one that covers from about 9 p.m. on the 12th till midnight. We'll continue to look for what they've requested, and as soon as if it's located, we will turn it over. 303 has been completed, 304 has been completed, and 305. The next series, 306, 307, 308, 309 are all part of the 2-week process. As detailed in our response, we've been told by the FBI that it's going through their process, and we're hoping to hear something back about whether or not these are approved and when they're going to be provided in early June. 313 is done, 314 is done, 315 is part of, again, the 2-week process, as well as 316. Again, we should know more early June. Back to videos, 317. The first thing they asked for is this US Bank video. That's been provided. Ampersand, to our knowledge, it doesn't exist. Again, we'll do our due diligence to make sure. If it's located, we'll provide it. One World Cafe does not exist. And 9 to 5 is actually US Bank, and that's been provided. Red Star Coffee, we have, and 319, 320, 321 are all ones that are still outstanding. We'll continue to try to locate those. If they exist, we'll turn them over. 324, 325, 326 have all been complied with. 334 does not exist, and there will be a supplemental report to that effect. 335, 336, 337, 338, 339, 340 have all been complied with, and that gets us to the end of the 5th for this hearing.
Thank you. Any response?
Your Honor, just really briefly, I want to talk about item 226, the Hemisphere program. Ms. Jennings asked me if we meant the timing advance program. That's one and the same. I just heard her say that those records don't exist. I just need to be clear, if they don't exist, then I need to know them. If they do exist and they were used, I need to have them. She mentioned that item 250, 250, that's the balance training records that we had. That we don't have that. That's balance training records related to the use of the Gladiator machine. We don't have those. 251 is partially complied with. That's the certificate on whether the Gladiator machine was working appropriately. We need the follow-up the next time that machine was put back for testing. Both machines, there were 2. 263 and 264, Balance and Kennedy's past training records. I'm happy to hear that I'm going to get those. With regard to the videos on exhibit RR that the court has under number 21, this is where the business said they already had given over their videos, and Ampersand and One World Cafe are both listed on that as well. So they were given to somebody to their Moscow Police Department at some point in time. And that's it for clarifications for me. Thank you.
Great. Excellent. Anything else? No. Okay, great.